I want to tell you about her before I tell you about the case, because by the time most people hear about cases like this one, the person at the center of it has already become a number in a file. She was not a number to me, she never was. There were 3 moments in that courtroom when the silence changed the day. The last one came after I finished speaking, when nobody moved and even the sound of breath seemed separate from the room. I will come back to that. But if I am going to tell this right, I have to begin where I began, with her name. Subscribe. Not for me, for the reason I am telling this. Some stories need more people to carry them than were in the room when they happened. Subscribe and help me carry this one. The first time Elena Torres walked into my courtroom, she held her shoulders tight, not like someone trying to disappear, but like someone used to being told she needed one more paper, one more number, one more reason to be allowed through a door. She wore a dark green sweater, though it was warm outside. She sat down carefully, opened her bag, and placed a folded pharmacy receipt beside her hand as if she might need to prove something at any second. What I noticed later stayed with me even more. On the second day of testimony, she took a child's inhaler spacer out of her bag, still in its plastic sleeve, and set it beside her legal pad. She never held it up. She never used it for effect. She just kept it near her hand. That kind of truth does not try to impress a room. It simply remains in it. The defendant was Daniel Mercer, 46 years old, emergency room operations manager at Mercy Valley Regional Hospital. He sat straight, watched the clock more than the witnesses, and spent a great deal of time lining up his pen with the edge of the table. People often think guilt looks wild or ashamed. Very often it looks organized. There was one moment when he appeared to me as a person and not just as a role. A school photo of Gabriel Torres was entered into evidence. Red polo shirt, one front tooth missing, the look children have when they do not know a photo will one day need to stand in for them. Daniel Mercer looked down then and pressed his fingers against the bridge of his nose. I remember that because it made the whole thing worse. It told me he was not unable to feel. He had felt and gone forward anyway. The incident happened on Monday, March 18, 2024, at Mercy Valley Regional Hospital on East Harlan Road in Brookmere County. The timestamp on the security video read 8:41 p.m. Elena Torres came through the emergency entrance carrying her son, Gabriel, age 6. He had severe asthma. Even on silent video, you could see the urgency in the way his chest pulled and the way she kept shifting him higher to help him breathe. Her Medicaid coverage had lapsed 12 days earlier because a renewal packet had been mailed to an old address. That mattered to the billing screen. It should not have mattered to the door she walked through carrying a child in respiratory distress. A triage nurse stood up when she saw them. Before the nurse could bring the boy back, Daniel Mercer stepped between the desk and the hallway. 2 staff members gave the same account, and the video matched their timing. Mercer looked at the screen and said, "If there is no coverage and no deposit, I am not opening a chart tonight." The nurse said the child needed to be assessed at once. Mercer said, "Then tell her county can take self-pay if she wants free care." He said it while Elena was still trying to keep Gabriel upright against her shoulder. Elena said on the stand, "I kept saying, please, just listen to him breathe." She said it quietly. She did not say it to move the room. She said it because that was what she had said that night. She was told Eastline Community Urgent Care was 6.2 miles away. Eastline had closed at 8:12 p.m. At 9:07 p.m., Elena called 911 from a gas station lot on Route 7 after Gabriel slumped forward in the seat beside her. Paramedics arrived at 9:13. They intubated him at 9:18. He was pronounced dead at St. Agnes Children's Hospital at 10:02 p.m. from acute respiratory failure after a prolonged, untreated asthma attack. Later that night, Daniel Mercer changed the intake record to read left before triage. I want to ask you to subscribe before I go further, and I want you to know that I do not ask lightly. What comes next is the part that cost me the most to say out loud. Subscribe. Stay with it. The case reached my desk the way these cases often do, in stacks: affidavit, incident report, amended report, policy manual, training records, backup server logs. People imagine the law receives a whole event. It does not. It receives pieces and asks whether they can bear the weight of what happened. There is one legal detail most people do not know. In a case built on a failure to act, the state has to prove duty before it proves harm. It is not enough to say someone should have helped. The law has to show that helping was part of the job, part of the authority, part of the promise made by the role itself. That was why the policy manual mattered so much. Daniel Mercer was not a bystander. He had intake authority that night. I could sentence the man who made that choice, but I could not reopen the door he closed. From the bench, I watched entrances closely. Elena entered first on the morning testimony began. From where I sat, I could see the top of counsel table before she reached it, and I saw her place one photograph face down before she sat down. No one else in the room could have seen that exact movement the way I did. She left it there until the clerk called the case, then turned it over and set her hand beside it. Daniel Mercer came in 10 minutes later with his lawyers. Most people in the gallery saw a man walking carefully in a navy suit. What I saw from above and slightly to his left was his hand stopping twice at the empty place where a hospital badge used to clip inside his jacket pocket. Habit reached for authority even after authority was gone. There were 3 moments in that courtroom where the room went completely quiet. Not the kind of quiet that happens between questions, the kind that settles when something true has entered the room and nobody knows what to do with it yet. I remember the whole case through those silences now. Before the first one, the evidence came in steadily. Security footage from the entrance camera, shift records showing Mercer was acting operations supervisor from 7 p.m. to 7 a.m., training slides stating in plain words that ability to pay could not delay an emergency medical screening, a compliance email sent 3 weeks earlier after an unrelated complaint, reminding Mercer that registration issues could not slow treatment of anyone in obvious distress. He had replied with one word, "Understood." The altered log mattered too. The original backup showed arrival at 8:41 p.m. and insurance flag at 8:42. The edited entry, saved at 9:26 p.m., read left before triage at 8:44. The pages looked almost the same. People think records are dry things. They are not. A changed record is a hand reaching backward toward the truth after the truth has already happened. Then Elena took the stand. She answered the simple questions first. Name, address, her son's age, how long he had asthma, what medication he used. The room was still a courtroom then, still a place of sequence and order. Then the prosecutor said, "What did Gabriel say in the car?" Elena said, "He asked me if we were leaving because I forgot something." That was silence 1. It lasted 11 seconds by the wall clock behind counsel table, long enough for one juror's substitute seat to creak, even though there was no jury in the room, because a member of the public shifted at the same moment and the sound cut through the stillness, long enough for the bailiff to stop moving near the door. It was a thin silence, the kind that comes when a room realizes a child did not know he had been refused. The prosecutor broke it by stepping back from the lectern and giving Elena time to drink water. What changed for me in that silence was not the law. The law already had duty, causation, record tampering, and time. What changed was the shape of the harm. Gabriel thought his mother had made an ordinary mistake. He did not know that money had entered the room before care did. That detail stayed with me because it placed the burden exactly where it belonged. After silence 1, the first wave of facts felt different. Nurse Mia Patel testified that Gabriel was using the muscles in his neck to breathe and should have been brought back at once. The paramedic captain said earlier oxygen and bronchodilator treatment would more likely than not have prevented the collapse. The hospital compliance officer testified that no deposit was required before screening and that Mercer had passed the annual policy test with a 98. The defense was careful. They did not deny the child was sick. They did not deny Mercer spoke to Elena. They argued confusion, crowding, divided responsibility, a misunderstanding of intake steps, and a break in causation because Elena drove away instead of calling 911 from the parking lot. I listened fully because listening is part of the work. and because sometimes the truth does hide inside a complication. Daniel Mercer took the stand on the fourth day. His voice was softer than I expected. He said, "I did what policy required." He said it as if repetition had made it feel solid to him. It had not made it true. Policy did not require delay. Training did not permit it. The nurse he overruled understood that before he claimed not to. Subscribe before I go further. I have more to tell. And the more I tell, the more it matters that someone is listening. Subscribe and turn on notifications. Then let me continue. The second wave of evidence came from places Mercer did not think would matter. Badge access logs, text messages, the testimony of Lila Gomez, the unit secretary on duty that night. She was not dramatic. She spoke in the flat voice of someone who had spent too long near systems that fail people and then leave the cleanup to whoever is left standing nearby. She said Mercer told her not to print a face sheet unless active coverage could be verified or a deposit could be taken. Then she said, "The boy never touched the floor." I wrote that down in my own hand. What she meant was simple. Gabriel had been in his mother's arms the whole time because he could not hold himself up. Around then, a memory from my own life came back into the room with me. My daughter was 8. It was winter. I had carried her inside after a late urgent care visit, still half asleep, still wearing the paper wristband because I had forgotten to cut it off. One sneaker hung loose and tapped against my leg with each step. The kitchen clock said 12:14 a.m. I remember setting her lunchbox on the counter beside the insurance card I had shoved into my coat pocket without thinking. Then I turned back to the case in front of me. During cross-examination, Mercer tried another line. He said, "I never wanted a child to die over paperwork." I think he believed that sentence helped him. Instead, it told me something he did not mean to reveal. Paperwork had been present in the moment that mattered because he made it present. Wanting a different outcome later did not remove the choice he made earlier. Silence. 2 came after redirect. Mercer's lawyer said, "Did you believe there was enough time to get to another facility?" Mercer looked down at the table and said, "I thought they had time." Then he said nothing else. This silence was not like the first one. Silence 1 belonged to innocence meeting consequence. Silence 2 belonged to consequence meeting itself. It lasted 8 seconds, shorter, denser, less startled. No one was learning a new fact. The room was accepting the final shape of responsibility. The court reporter broke it by saying the answer back for the record, though everyone had heard it. He said, "I thought they had time." I wrote it down. I looked at it for a long time before I moved on to the next page. The defense came closest to giving me real pause on causation. That question mattered. Traffic was slow on Route 7. East Line was closed. Elena did not call 911 from the hospital lot. I considered all of that carefully. The pause ended when the pediatric pulmonologist explained in plain terms that the window for effective emergency treatment was those first minutes at Mercy Valley. After that, the road between choice and loss was no longer blurred. Subscribe. I am not going to make a case for it. You are already in this story. Subscribe and let me finish it. I found Daniel Mercer guilty on all counts. Because he had waived a jury, the finding was mine alone. People sometimes think that makes things simpler. It does not. It only means fewer people are carrying the moment out loud. The sentencing hearing took place 3 weeks later. Elena wore the same green sweater. Daniel Mercer wore a gray tie. Gabriel's school picture stood face up on counsel table. Before I told the room what I was ordering, I felt again the edge of that final silence waiting ahead of us. I had made the decision carefully. I had made it knowing that careful decisions and right decisions are not always the same thing, and believing that in this case they were. I said, "Daniel Mercer, on count 1, I sentence you to 5 years in state custody with 30 months to be served and the balance suspended, followed by 5 years of supervised probation. I said that because a child's need for care was delayed by choice, not confusion, and because public trust means very little if the person at the desk can put cost in front of urgency and call it process. I said that those 30 months are not equal to a child's life. Nothing is. They are the law's way of saying that when someone with duty stands between an emergency and treatment, We answer that as harm. Then I turn to the financial part. I am ordering you to pay a fine of $250,000 to the Gabriel Torres Pediatric Emergency Access Fund to be established through Brookmere County Children's Clinic within 60 days. I chose that because money had been used as a gate in a place where there should have been no gate. The response needed to go directly toward lowering that same barrier for other families. I said that fund will be used only for uninsured pediatric emergency transport, rescue inhalers, and bridge medication for families in lapse or appeal status. The harm in this case had a shape. The remedy should have one too. Then I said, I am ordering the immediate suspension of your healthcare administration license and any emergency intake supervisory privilege for 10 years. That was not for appearance. It meant he could not sit in a position where cost might again be weighed against a medical emergency. It meant he could not supervise the kind of desk where minutes matter more than policy memos ever will. I said, this restriction is based on training received, authority held, warning given, and a record changed after the fact. The public has the right to know that the people controlling access to care understand what that control means. The educational part mattered to me deeply. I am also ordering 1,200 hours of supervised service at St. Luke Free Respiratory Clinic and the County Mobile Asthma Program to begin after release and to be completed within 3 years. Not generic hours, not a task far away from the offense. I wanted him where inhalers are counted, where parents ask how long a sample can last, where a child's breathing is not abstract. I said, you will not perform this service in a back office. You will work intake under supervision, distribute supplies, attend patient education sessions, and submit written reflections every 90 days. If distance helped create this harm, part of the sentence must remove that distance. And there was one more thing. As a condition of probation, you will stand in the main lobby of Mercy Valley Regional Hospital on the first Monday of the next 3 months at 9 a.m. and read a written statement aloud. I required the hospital board, emergency department staff, registration trainees, and patient advocates to be invited. The statement had to name Gabriel Torres, state that emergency care cannot be delayed for inability to pay, and acknowledge that a child was turned away while in distress. I did not order that to shame him for sport. I ordered it because a wrong carried out in a public institution should be answered in public language, in the same kind of place where it began. Then I gave the restorative part. You are ordered to pay restitution of $86,400 for funeral costs, missed wages, counseling, and transportation tied to this case. Then I added the part that reached closest to the family's future. You will also fund 5 years of respiratory care for Rosa Torres, including specialist visits, controller medication, 2 home nebulizer units, and transportation vouchers. This court heard testimony that Elena Torres delayed follow-up care for her daughter after Gabriel died because she could not bear another billing window. What happened here cannot be allowed to keep reaching through the rest of that family. I have not told you what I ordered yet. I'm about to. Subscribe before I do, not because it is dramatic, but because I want to explain every part of it, and I want you to be here for the explanation. Subscribe now. Then I addressed Daniel Mercer directly. I said, what you did can be measured in minutes, in 1 altered line in a record, and in 1 child's time of death. It can also be measured in what Elena Torres now carries through every grocery store, every school hallway, every night when another child coughs in the next room. Those measurements are different. They belong to the same act. I said, to your wife and son seated behind you, this sentence reaches into your lives too, and I will not pretend otherwise, but the choice that brought it here was yours. Then I said, your position required one thing above all. When urgency came through that door, you were to let care move faster than cost. You chose the reverse. My last sentence to him was not about him. I said, Gabriel Torres should have grown older than this courtroom. Then silence 3 arrived in full. It lasted 14 seconds. From the bench, I could hear the ceiling vent and the faint click of the reporter setting her machine aside. No paper moved, no chair scraped. Elena did not cry right away. Daniel Mercer did not turn around. The air felt like air feels when a permanent thing has just been spoken and nobody in the room has found a smaller shape for it yet. The one reaction I remember most came from Mercer's wife. She placed her hand flat between his shoulder blades and left it there. Then she removed it before he looked back. "Thank you for staying with this. I mean it in the specific way you mean something when it cost you something to say. Subscribe if you have not yet. You already know why you are still here." As the courtroom began to empty, I was still seated. Elena's sister Marisol stood first. She went straight to Elena, crouched beside her chair, and said, "Breathe, Elena, just breathe now." I was close enough to hear that. The same word returned to the room in a different form. Elena placed her hand over the lower corner of Gabriel's school photo, not over his face, just over the printed school logo. When I finally stood, the room was almost empty. What I noticed was that both counsel tables still had water glasses on them, and neither glass had been touched after the sentence. The appeal was filed 31 days later in the 2nd District Court of Appeals. Daniel Mercer challenged the sufficiency of the evidence, the admission of the altered log, and the probation condition requiring public acknowledgement. The appellate court heard argument on June 11, 2025, and affirmed my ruling on September 9, 2025. In plain language, they said the evidence showed he knew his duty, knew the child was in distress, and chose delay anyway, and that the sentence was tied in a reasonable way to the harm proved at trial. The process took just under 15 months. I read the ruling at my desk and sat there a little longer than I needed to. On October 17, 2025, I received a letter from the director of St. Luke Free Respiratory Clinic about Mercer's service placement. She described an uninsured father arriving with a wheezing little girl and saying 3 times that he did not have active coverage. She wrote that Mercer handed him the clipboard and said, "You are in the right place. Sit down. We'll get the nurse." I read that sentence once. Then I read it again. I will not tell you what to do with it. I only know that it happened. The question this case left me with is not whether the law can punish a person for what Daniel Mercer did. It can. It did. The question is smaller and harder. How many people have already been trained to hesitate at the wrong moment because a screen taught them to look at cost before need? I have thought about that for a long time, and I still do not know. What I do know is that grief and clarity are not opposites. If you sit with grief long enough, it often tells you exactly what was lost and exactly where the losing began. In this case, the losing began before the child died. It began the moment urgency had to explain itself to a billing screen. If you are someone who has stood where Elena stood, I want to speak to the expression I saw on her face the first morning she took her seat. It was not just sorrow. It was the strain of a person who has already had to stay polite while proving that an emergency is real. I have seen that look before. It is what the face does when dignity has to keep standing while fear is already kneeling inside it. And if you sit where Daniel Mercer once sat, or in any place where your decision can slow help, there is a question I wanted to ask from the bench but could not because it was not a legal question. What did you think would happen to you if you simply opened the door? I will offer one thing. Before your next shift, write the word "now" on a card and place it where your eyes go first. That is not legal advice. It is a human instruction. There is one more thing Elena said that has stayed with me. It came after the sentence, after the deputies moved, after the lawyers began collecting their papers, as if paper could help the room become ordinary again. She said to her sister very softly, "They said his life counted." I have said that sentence back to myself more than once since the case closed. Not because it finishes anything, because it states the minimum truth plainly. I opened with Elena, and I want to end there too. Elena in the green sweater. Elena flattening that pharmacy receipt with her thumb. Elena hearing at last words that should never have required a courtroom to be spoken aloud. That is why I told you this story. If you want to hear the others, and there are others, subscribe. That is all I'm asking. Subscribe and stay. And if you speak in the comments, speak the way people speak outside a hard room after the door opens, when strangers realize they care about the same thing.